Hello, my dear students. Welcome to the part 5 of series of 10 most important static concepts that you have to study for this year's CLAT. Okay, so today is the fifth part, and today we will be studying the miscellaneous portions. In the last parts, we have studied all the important static portions. In today's part, we will study those concepts which are not per se subject, but they are certain concepts or principles or doctrines, and they have been asked in the past papers, and they are very commonly used, and there is a high probability that such questions or questions revolving around these concepts can be asked in this year's CLAT. All right, so let's begin with the class. So the first most important topic under the miscellaneous section is the concept on patents. So what is a patent? The Indian Patents Act 1970 grants patents or grants inventors exclusive rights to their inventions for 20 years. So it is granted for a specific period, provided the invention is, point number one, novel, point number two, inventive, and industrially applicable. So these are the three requisites that are to be satisfied when you want a patent for any invention of yours. Patents in India cover processes, machines, and manufactured articles, but exclude items like scientific theories, okay, so like the law of gravitation. So you cannot get a patent over law of gravitation. Einstein cannot get a patent over something that he discovered, okay. Then and natural discovery, something that is natural. For example, the law of gravity. So you cannot get a or any natural fossil fuel that has been discovered, or let's say an ancient animal, let's say a dinosaur that existed millions of years back. Some dinosaur, because of the new discovery of, let's say, their bones, it has been discovered. So you cannot say I want a patent over the bones. It is not possible. The application involves filing with the Indian Patent Office, publication, and examination. The patent holder has exclusive right to make, use, and sell the invention, but must pay annual fees to maintain it. So annual fees is not very much. It is quite negligible compared to the benefit that the owner gets by holding exclusive right to the patent. Okay. So what are the rights of the owner? He can make, he can use, so he can use it for his own purpose. Suppose someone made a patent, let's say, over a four wheeler, one of the fastest car in the world, and there is a patent over the design, okay, because it consumes very less fuel and it gives maximum speed. So there is a patent over the engine technology, okay. So this patent is there. So the patent holder, let's say X person, made this engine technology, so he can make it, he can use it, he can manufacture a car of his own and use the same technology there, or he can sell. So selling is the most commonly used way by which patent holders sell their rights. Why? Because generally the discoverers or the inventors, generally they are not industrially capable to to apply it. So generally they sell their invention, and the company that buys it, they produce it industrially and they gain profit out of it, okay. So suppose he sells his engine technology to another company, let's say XYZ, and then the company pays him a price, and then this company makes, let's say, thousands of car or millions of car over using this technology. So company also benefits and the patent holder also benefits. So this is how the entire system works. Compulsory licensing provides or compulsory licensing provisions enable the government to allow others to use a patent in public interest, ensuring accessibility and affordability of essential goods. Now, see, generally this is in the context of medicines. Now, in India or worldwide, there are certain life saving medicines or drugs, as we call them, medicinal drugs. Okay. So, these drugs or these medicines can save thousands of lives. Let's say there is a new drug that has been discovered, or which has been made by intensive technology by scientists, intensively working, and now they have come up with a drug which is able to cure cancer. Now, this scientist, suppose the company that buys this patent, they pay a good royalty, good amount to the scientist. Now, they are selling this drug at the cost of rupees, let's say 1 lakh per medicine or per unit. So So for one capsule, they are charging 1 lakh rupees. They can do because they have purchased. They can even price it at 5 lakh. Now, can common people purchase it? 1 lakh per unit, and suppose every month you have to take one unit. So the entire cost comes to around 30 lakh rupees. Is it possible for common man in India to afford it? 100% no, not possible. So in this case, under in Indian in Indian Patents Act, there is a provision which is compulsory licensing. So if in public interest, okay, the government, or it comes to the knowledge of the government, there is an essential good, and it is necessary that it is to be priced reasonably, then the government can issue compulsory licensing to some third party and ask them to manufacture the same drug and sell it at a reasonable price. Let's say 20,000 per drug or 15,000 per drug, like that, whatever the common man in India can purchase. So this can happen in cases of essential goods, but not every good. So same thing, if the car manufacturer, now if the company is making the engine, and now the new manufactured car they are selling it, let's say 10 crore rupees per car. Now car is not an essential good, it is a luxury. People can survive without cars also. You can walk, you can take a bike, scooty, different ways of commutation are available. Car is not necessary. You may not buy this specific engine car, you can buy other cars, okay. But in case of essential goods, CL or compulsory licensing is applicable, not in case of any other good. Okay. So medicinal drugs, cancer, which is only life-saving drug. In such case, you can apply CL and not in any other case. Okay. So remember this point. So mark these words: essential goods and not luxury or other goods. Okay, so this was the basic understanding and basic theory behind patents. It is a very important topic, and another area in which questions can be asked is the three essentials. That is, it must be novel, inventive, and industrially applicable. Now, suppose someone discovered a drug. Okay, they made a drug. Now, the same drug, another is already in the market with little bit variation. Novel means something that is new. So the scientist who made the new drug, he cannot say that he cannot get a patent. Why? The patent office will say, sir, your product is not novel, in the sense it is not new. We want a new product, something that is not already available in the market. So this is compulsory to be there. Okay. Second is inventive. Some you must have done something to do it. Okay, not like that naturally you get something and you say I want a patent. No, you must have worked upon it. So it must be inventive and industrially applicable. Now, suppose you made a medicine. Okay, you made a medicine using article XY. Now, let's say, okay, let me take a very practical. Now, let's say there is a flower. Okay, now the extract of this flower is able to cure, let's say, TB. Okay, so you harness the extract of the flower and make a wonderful drug out for TB. And now this is all right. Okay, now the point is you want to sell it in the market, but this flower was the last flower that was present in the world, and now it has become extinct. So you cannot extract the TB drug that was earlier there in the flower. So you cannot make the drug, or you can make only 5 6 quantities or a limited number, not more than that. So in this case, the invention is novel, it is inventive, but it is not industrially applicable, meaning that it should be able to be produced in massive quantities for the masses. Okay, this is a essential requirement. So these were some of the areas in which, if there is a question on patents, it can be asked on these areas. Let's proceed to the next concept. So copyright. Under the Indian Copyright Act 1957, copyright protects original literary. Literary means what? Anything that is written. Okay. Let's say you write a beautiful poem. So that is also a subject of copyright. Artistic, you write a wonderful song, or you write any, let's say, dialogues of movies, comedy dialogues, like comedy. So Kapil Sharma show, you all must have seen one of the famous comedian shows in India. Now he is what he's doing. He's doing a artistic work. So all the dialogues that these guys are using, they can be copyrighted, meaning they can be protected. And musical means any song that you're writing. All the songs, if you go on YouTube or other places, you will find that all these songs are copyrighted. Like this one mono is there. This mono says that the song cannot be further produced, it is a copyrighted material. And cinematographical works, meaning films, all the films that we are seeing. Okay, Bollywood, Hollywood, Tollywood, South Indian, all kind of movies, Marathi, Gujarati, Bengali, All movies, all cinematographical, not only Bollywood. Even if it's a 30 minutes reel or if it's a 1 minute video, all those come under cinematographical works. Granting creators exclusive rights to reproduce, distribute, and perform their work. So anything which is literary, artistic, musical, or cinematographical, you get a right and you create something, so you are a creator. Okay, suppose you write a new song. Okay, so you are a creator, so you get exclusive right to reproduce it. It is your right whether you want to distribute it to someone or keep it to yourself and perform the work, or you want to host it on any public platform. Let's say you want to conduct a concert, or you want to post your song on YouTube. That is your right. So this is copyright. Basically, it is protecting you from others. So if you have made something, others cannot copy it. That is why the name copy and write. Because suppose you made a wonderful song, the name of the song is tu hi hai meri. Suppose this is the name of the song. Okay, now you have made the lyrics and wonderful music you have given. Now you have posted it on public platform. Some X person is copying this song of yours and posting it on his channel. So what will happen? If suppose your channel is also monetized and X channel is also monetized, so X will get all the profits out of it. So in this case, you can file a case and say there was a copyright on this on my work and you cannot copy. And if he is copying, you can file a case and you will get all the revenues that he earned into your account. Okay, so this is the meaning of copyright. Okay, so but it is important to get the copyright. Automatically, if you're making a work and you're not getting a copyright, it is not automatically copyrighted. You have to get it, you have to apply for it as per the law. So in India, there is a law which is Indian Copyrights Act. Under this law, there is a procedure that is mentioned, so you have to do it. Okay, so this is copyright. This protection lasts for the creator's lifetime plus 60 years after their death. So whenever you created, from that time till you are no more, and 60 years hence. So this is the time period. For companies, the term is 60 years from the date of publication. So suppose if it's a company, then the date when the article was produced or it was publicized in the public, from that date, suppose it was publicized in 1970, so plus 60. So this will come to 2030. Okay, so anytime after 2030, the the movie or the song or whichever literary or artistic work, it can be publicized or you can use it, or the copyright will end. But if you do it before, from 1970 to 2030, this is 60-year period that the company is getting. If you use it during this time, if you copy it, then the company can file a case of copyright violation against you. Copyright does not protect ideas, facts, or concepts, only the original expression of these ideas. Indian laws allow fair use for purposes like research, education, and criticism. So, mere idea, I think the moon is spherical. I think there are 9 planets in the solar system. So, what are these? These are mere ideas or facts. The sun rises in the east and sets in the west. This is what? This is a fact. Everyone knows it. So, you can't get a copyright over such things. Or concepts. Now, let's say any concept. So, you can't get a copyright over a concept. Okay. Only original expression of these ideas. So, it must be again something original. Okay. So fair use. Now there is an exception to copyright, which is fair use. Okay, so suppose there's a song. Now you must have seen parody are being made or certain clip of a video or a cinematographical work. It is copied and then some other thing is made on that, let's say 10 seconds, 15 seconds clip. Now this is not copyright infringement. Why? Because this will come under the exception fair use. It says that for research or for education or for criticism. Now let's say research, let's say there is a drug, okay, or let's say there is a music let's say there is a literary scientific work, a scientific journal, some article has been published. Now you are researching that work, okay, or you want to get something and or manufacture something new or invent something new. For that you are referring to that journal. Now you use that journal's pages to publish your own work. In this case, the person cannot file a case of copyright infringement against you. Why? Because you're using it for research. Similarly, if a class teacher, let's say if the teacher is taking certain videos or audio clips and expressing it, telling it in the class, suppose I only do it and say, let's see, this song is copyrighted like that, so there can be no violation of copyright against me. Why? Or against the educator. Why? Because it is being used for educational purposes and not for profit purpose. And criticism. Now you must have seen whenever a movie is released, there is a review. So for the review, The person has to see the movie. So if you see the movie and if you are reviewing, it won't come under copyright infringement. Why? Because this is for criticism. So these are some exceptions which come under the umbrella term fair use. Copyright holders can license or transfer their rights, and infringement can lead to civil and criminal penalties, supporting creators' financial and moral rights. Okay, so infringement can lead to cases against the person who's infringing the rights. Okay, so this was the second most important concept of copyright. Let's come to the third important concept under miscellany, which is polluters pay principle. This has been asked why, because this comes under environmental law, and environmental law is a very running theme, a very important theme from CLAT perspective. So many questions, if you see in the past, they have been asked. So polluters pay principle is an environmental policy approach where the party responsible for pollution bears the cost of managing it and to prevent environmental damage. This principle aims to hold polluters accountable, incentivizing them to reduce pollution and adopt sustainable practices. Costs include cleanup, damages, and environmental restoration. By internalizing the cost of pollution, this principle discourages harmful practices and promotes responsibility. Okay, so the company will be fearful that if I do something, then I only have to manage. So this is the principle. In practice, government may impose taxes, fines, or fees on polluting activities, or require companies to cover the cost of waste management and emission controls, ensuring that the burden of pollution isn't shifted. So basically, making the polluter pay for whatever harm he's doing to the environment. Let's come to the next concept. So NGT codes, this is also a concept under environmental law only. So the National Green Tribunal is a specialized judicial body in India established in 2010 under the National Green Tribunal Act to handle environmental dispute. So specific code related to environment, and the name is National Green Tribunal, only for environment, because environment is a very, very important theme. If we don't protect the environment, one, we may not survive. So now specialized court only to cater to environmental disputes and not other any other dispute. It addresses cases related to environmental protection, conservation of forests and natural resources, ensuring that development projects comply with environmental laws. The NGT has the authority to provide compensation for damages to individuals, property, and environment. Its processes are quicker and more streamlined than traditional courts. So these are the benefits. As it operates on the principle of natural justice and prioritizes environmental conservation. With headquarters in New Delhi and regional benches, the NGT helps enforce the polluters pay principle and promotes sustainable development. Okay, so as I told you before, that the polluters pay principle is also a part of environmental law. Okay, so let's move on. Ignorantia juris non excusable. So ignorance of law is not an excuse, is a legal principle asserting that individuals are expected to know and follow the law, even if they are unaware of it. So if you don't know some law, suppose you don't know that peeing at a place and there is a fine for peeing at, let's say, some area is there and nothing is mentioned there, and but there is a small board here which is saying urinating or peeing in this area, fine 500 rupees. Now if you go and do that and later some police guy, he is catching you, now you cannot say, oh, don't fine me. Why? Because even if you're and you say, I don't know that if you pee here, then you get a fine, you cannot take that excuse. Why? Because if you don't know the law, that is not an excuse. The law will apply. It is your duty to know the law. This doctrine prevents people from avoiding legal responsibility by claiming that they didn't know the actions were illegal. The example that I told you. It promotes accountability as laws are often publicly accessible, giving citizens the chance to understand them. Applied universally, this principle ensures fairness in legal proceedings by treating everyone equal under the law. Exceptions may exist in cases involving complex or highly technical regulation where reasonable unawareness is recognized. So, reasonable exceptions can be there, which are highly complex and technical regulations, not normal. So, reasonable exceptions are also present under this concept. So, let's move to the next concept, which is matrimonial law. So, under Hindu marriage law in India, the Hindu Marriage Act 1955, it governs marriage, divorce, and succession for Hindus, Buddhists, Jains, and Sikhs. So, when we say the act, it includes the other three religions as well. Marriage is legally binding if it meets requirements like age, soundness of mind, and absence of close kinship. For example, a brother and a sister, this is a close kinship, they cannot marry. Okay, why? Because it will be prohibited by the principle of close kinship. Similarly, if a person is 10 years of age and another, the boy is 10, the girl is 10, they cannot marry. Why? Age. So there is a minimum age for marriage for boys and minimum age for marriage for girls. So again, reply in the comment section if you know what is the minimum age of marriage for boys in India and the minimum age of marriage for girls in India. Okay, divorce is allowed on grounds such as cruelty. So divorce. So earlier, before the Hindu Marriage Act, no such concept as divorce was recognized in India. After the passing of the Hindu Marriage Act, this concept has been recognized, and now divorce is available. But it is not easy, and it is available only on specific grounds. Okay. So what are those grounds? So some of the grounds are like cruelty, if the party is treating the other party with cruelty, or desertion, or adultery, and mutual consent. Upon divorce, maintenance and alimony may be awarded to the spouse. Okay, so this is gender neutral. Okay, so if the cruelty is by the husband or the wife, whichever party, you can get a divorce. It is gender neutral. Succession is governed by the Hindu Succession Act 1956, which defines inheritance rights. Sons and daughters have equal rights in their parents' property. Okay, so after the 205 amendment, now even daughters have got equal share with the sons. Earlier, it was only the male sons who had the right. Now, daughters also share the rights equally, as if they will be treated as if they are males only. This law promotes gender equality and provides a structural framework for Hindu family relations. Okay. Now, the seventh most important topic is some important concepts under international law. What is international law? So, international law is a system of rules governing relationships between states and global entities. Okay. Key concepts include sovereignty, where states have authority within their jurisdiction, meaning, so suppose India is there. So, India has exclusive jurisdiction or sovereignty over the territory that it is holding. So, if laws have to be made in India, India will make it. Pakistan, China, Sri Lanka, Bangladesh, US, Europe, or any other country cannot dictate. Sovereignty means absolute freedom to decide for your own good what is right and what is wrong. So, that power is with India. No external foreign party is ruling. So suppose let's take an example. Before independence, it was the Britishers that was ruling India. So that time we cannot say that we are sovereign. Why? Because the authority or the real power to decide what will happen in India was with the Britishers. Non-intervention, meaning states should not interfere in each other's affairs, and because each state is supposed to be sovereign. And jurisdiction, defining the legal authority of states over people and event. Okay, so India has jurisdiction over the entire territory that it is within it. So if it wants to make a law in India, it can. So that is jurisdiction. Treaties are binding agreements between states, while customary law arises from consistent international practices accepted as law. Human rights standards protect individuals globally, so there are certain human rights also that have been recognized under international law and international organizations like the UN. So there are many international organizations, but UN is the most important because it has almost all countries are on board. Okay, so that's why it has a prominent role over other international organizations. So it has a role in conflict resolution, peacekeeping, and settling global norms. The principle of self determination also affirms people's right to choose their political status. So India, when we were asking for independence, what was the concept there when Gandhiji, Pandit Nehru, Dr. Ambedkar, and all these great leaders, when they were fighting for independence? What did the masses led by these leaders say? They said that we want to determine on our own whether you want independence or not. The Britishers cannot or the foreign party cannot decide. So this is known as the principle of self determination. People will decide whether we want to become a country or not. Okay, so India or everyone wanted to become an independent nation. Mostly majority, unanimous majority in India wanted to be independent and have a separate country and not be ruled by Britishers. Okay, so this is a principle. So later on, if you see in the 20th century, the second half, if you see other countries like many South Africa and other African countries also got independence, and the same principle was applied that people want to have their own government. They do not want the Britishers or other European power to rule their country. So this is a very essential principle, and it has been recognized also under international law. Okay. So tomorrow, if some foreign party is ruling right now, almost all countries are independent. There can be other government failure or other problems, but generally no others, no country is ruling other country. Generally, if you see, at least on paper. So, if the people of a country or a region say that we want to determine for our own self what which country we want to be in, so this is a very recognized principle under international law. So the next principle is your public interest litigation. So many times it has been asked in CLAT, and every time if you're reading newspaper, every second or third day you'll read PIL filed in Supreme Court, PIL filed in High Court of Delhi, PIL filed in High Court of Kerala or Karnataka. So what is it? So PIL in India allows citizens to seek justice on issues affecting their public interest. So anything that is affecting public, you can directly approach the Supreme Court or the High Courts. Initiated in 1980s by the Supreme Court to make justice more accessible, PIL enables individuals or groups to file cases on behalf of those unable to approach the court, such as the marginalized communities. PIL cases. So if there is a poor, or let's say the people are very poor and they are uneducated, they don't know what to do if their rights are getting violated. In that case, any public spirited person can approach the court on their behalf. So generally, for marginalized community, this special provision is available under the Indian legal system. PIL cases typically involve matters like environmental protection, human rights, and social welfare. Unlike regular cases, PIL can be filed directly in the Supreme Court under Article 32 or the High Courts under 226 without a personal stake. It strengthens democracy by holding the government accountable and ensuring people's rights or citizens' rights are upheld in the public interest. Okay, so let's move to the second last concept for today's discussion, which is your separation of powers. Now, what is this doctrine? Let's read the let's read the what's given in the facts. Okay, the principle of separation of power in the Indian legal system divides government responsibility into three branches: the legislature, the executive, and the judiciary. This structure ensures that no single entity holds unchecked power. The legislature or the parliament makes the law, the executive or the government implements and enforces them, and the judiciary interprets the laws and adjudicates the dispute. Each branch operates independently with checks and balances to prevent abuse of power. For instance, the judiciary can review legislative and executive actions for constitutionality. This separation aims to protect democracy, uphold the rule of law, and ensure accountability within the government framework. Okay. So basically, there are three branches. So, as the saying goes, that power corrupts and absolute power corrupts absolutely. So, if the power is concentrated only in one hand, there is a greater chance that it can be misused. So, the power is divided. Okay. So, under the doctrine of separation of power, there are three wings, which is the legislature, executive, and judiciary. So, in India also, we have the judicial system, Supreme Court, High Court, and District Court. Executive, which is the bureaucratic setup, which is at the central level and state level, and then the district level or municipal level, and legislature, where you have parliamentarians and state legislative assemblies, and the third is the municipal level. So, three levels, whether it is executive, judiciary, or legislature, we have it in three tiers. Okay, so it is all divided. No one person is making the laws and implementing and interpreting. There is no one person. There are three specialized wings which are dealing with it. So this is the doctrine of separation of powers. Let's come to the last topic for today, which is hierarchy of courts in India. So the hierarchy of courts in the Indian legal system is structured to ensure efficient administration of justice. At the top is the Supreme Court. So Supreme Court is the highest court, the highest appellate authority dealing with constitutional matters, fundamental rights, and significant legal issues. Below it are the high courts. So Supreme Court is on the top. Below it are the high courts. So if there is an appeal, it will go from the High Court to the Supreme Court. An appeal from the Supreme Court cannot come to the High Court. Why? Because Supreme Court is the highest legal judicial wing. Okay. Below it are the high courts in each state. So each state has a high court. For example, Gujarat will have one high court, Madhya Pradesh will have one high court, like that. Each state, which hear appeals from lower courts and have jurisdiction over state laws. Subordinate to the high courts are the district courts. So below this, you have the district courts, which are in the each district. So this is present at Delhi, which is at the central level. This is present at each state, and this is present in each district. So this is the administration of justice that happens in India, handling civil and criminal cases at the district level. Finally, there are various magisterial courts and civil courts. So this district courts mein there is further sub-classification which address local disputes. This tiered system allows for an organized and accessible legal process. Okay, so this is basically the hierarchy of courts as operates in India. So if there's an appeal, it will go from the district court to the high court, from the high court to the Supreme Court, and not vice versa. So from the lower to the upper, it can go, but it cannot come from the upper to the lower. This is the Indian hierarchy of courts. Okay, so this was the last topic for today. I hope you guys enjoyed it. If you have any questions, you are most welcome to ask. You can reply or ask in the comment section. I'll be happy to answer. Thank you, everyone. It was nice talking to you. I hope you guys enjoyed the session. And let's meet next in the next session, which will be the next part of the most important topics for CLAT 2025. I wish you all the best for your exams. Bye bye. Take care.